like different TV series out of it, can further license it to some comic book publication house, maybe to create a comic strip out of it, like various kinds of other things. So assigning is basically for a limited and time and for a particular objective, whereas transferring of copyright is basically the giving away of entire and all rights vested with the holder. Yeah. Yeah. Now the question of public domain. Yeah. So so all kinds of IP basically, like other than trademarks, like it comes with a particular time frame. Yeah. So for copyright it is 60 years. For patents it is 20 years. For trademarks it is 10 years and renewable indefinitely. So if you are continuously using a trademark, and you are like renewing it each and every year, then sorry, you are renewing it each and every term of 10 years, then you can hold a trademark in perpetuity. Like it will only like expire once you have not renewed it, like once your term has expired. But for copyright and for patents and other forms of IP, or also designs per se, like you cannot, like it is not extendable. For copyright it is limited to 60, like lifetime of the authors plus 60 years, which is why you see that like books written by William Shakespeare and let's say George Bernard Shaw, like you will see that their books are basically published by Rupa publications. It is available from Penguin publications, and all publication houses like make their own copy of it. That is why, because like that particular work has fallen into public domain and the copyright over it has expired. Yeah, as opposed to, let's say, like I'll go to the next example of Three Idiots. Like this was like a real time instance that had happened. Yes. So over here, what had happened was the book was written by Chetan Bhagat, and the like no due credit was given to him in a proper manner while making the movie by Vidhu Vinod Chopra production house. Yeah, and this entered into a big controversy where Chetan Bhagat publicly claimed that they are not, like he's not being acknowledged, and it led to an initial media battle of 5 6 days, after which it was solved amicably, and like whatever credit that Mr. Bhagat thought he deserved was duly given. Yes, so this is the reason why like a book that is written by Chetan Bhagat, which has only been like in existence for 10 years, it is not in the public domain. Like the author still has rights over it, and he will continue to keep it till his lifetime plus 60 years. Mm. Yes. So now what happens when public when a work enters public domain? So it is available for free, like it is freely, like it is available freely for public use, and it is no longer available for public, sorry, private ownership. And the examples are like like William Shakespeare's entire body of work, King James Bible, etc., etc. Yeah, and even the Happy Birthday song. So I was researching. So the Happy Birthday song that we sing, the generic one, that Happy Birthday to You. So that song was also initially, like it had copyright over it, and it was created by two fellows called Warner and Chappell. Yeah, but it was made so long ago, back in the 18th century, that after that, like it has fallen into the public domain, which is why everyone can freely like sing that song, like in their in their friends or their relatives' birthday. Mm. Yeah, and now another thing that needs to be taken care of over here is this, that see, like the term of copyright for 60 years, like that is only there in India. Yeah, and like various other countries, they have their own timeline for it. Like certain countries have 50 years, certain countries have 55 years, and certain countries have more than India, like 70 years, 80 years, or things like that. So that depends on, like, that exclusively depends on the discretion of the legislatures who have particularly drafted the law of each and every country. Yeah, but then there's one international treaty called the Berne Convention, which basically mandates that all countries are required to give a minimum protection of 50 years. Yeah. So and in India it's 60 years. So then, so a very important thing to remember is that it varies from country to country, and it can be possible that a particular work is is in public domain in one country and it is copyright protectable in another country. Like, let's say some other country, let's say Nepal. Like, I have to check what is their exact time frame, but let's say I'm like assuming that it is 50 years. Yeah. So then in that instance, like any particular work which has been produced 50 years before, will lose it, like will enter the public domain in India, but will keep on copyright over it for additional 10 years in India, because India's term is for 60 years. Yeah. Yes. So now moving on to certain other basics like copyright and infringement. So infringement is basically when you are violating someone else's copyright over any particular subject matter. Yes. So I'll just give you a like certain briefs over it. Yes. So like before we go into infringement, we have to explore the concept of originality. Yes. So the concept of originality is something that is very important in copyright law, and that is the basic genesis of everything under copyright law, because if it's like you get the protection only because it's original. But then how courts have defined the term originality is something that needs to be looked into over here. Yeah, yes. So originality is an aspect of a work that makes it uniquely unique, thereby distinguishing it from reproduction, clones, and forgeries. So, as per the Copyright Act, originality is one of the requirements to get a copyright, but it is not defined in the Act per se. And a basic rule of law is that when something is not defined by the legislature, what you do is you look for judicial precedents for a particular definition. Yes. So, what are the judicial precedents? So overall, like over the period of time, several judicial decisions have laid down the parameters of what would be deemed to be original. So the two parameters are sweat of the brow doctrine and modicum of creativity. Yes. So initially, what was the case was, so initially India followed the sweat of the brow doctrine for a long period of time. So the sweat of the brow doctrine is basically this, that like with regard to originality, whenever someone creates a work, they have to like to test its originality. We have to see that how much of the sweat of his brow he has investment in, like he has invested in it. So it is basically a higher standard of originality where the degree of effort is to be looked into and then judged whether it's original or not. So the initial sweat of the broad doctrine which India used to follow had a higher standard, and initially the that was the rule. But then over, like what happened was, the like in 2007, the Supreme Court of India, in the case of Eastern Book Company versus DB Moda, yeah, so they basically made the like they laid down the modicum of creativity doctrine, which lowered the standard of originality, and it basically mentioned that it need not be this, that the entire effort, how much of effort has been invested in it, needs to be taken into context together. What needs to be seen, that there is a minimal degree of creativity. Yeah, so this Eastern Book Company and DB Modak is basically something that related to Yellow Pages. Yes. So now what happens is this, that that like for instance, all these telephone diaries diaries and everything that we have. Yeah, so is like for instance a very famous publication house already makes like all those telephone diaries with everyone's numbers. Yes, so what we need to see is that, like for instance, if someone else like literally copies the entire thing, yeah, and makes their own telephone diary and publishes in their own name, then will it be copyright infringement? Then the answer is yes, it will be, like if it has been entirely copied from entirely copied verbatim. But then if that the second person can show that they have a minimal degree of creativity, like let's say what that person has done is that in the whole table, like where the number, the name of the person, the address, and everything has been mentioned. Yeah, so that the second publisher just adds certain other personal details of it, like the father's name of the person. Yeah, which was not there in the initial publication of the telephone diary. Yeah, so the fact that a new column of information has been added into the table means that a degree of minimal creativity has been used in that particular product, and the new work is not a violation of copyright of the earlier work. It is basically a new work in itself. So these are the two standards of originality. So currently we follow the modicum of creativity standard, which lays down that the creativity should be there, but even a minimal creativity will be uh, 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 will suffice. Yes. Now coming to the real subject matter at hand, like what amounts to copyright infringement. So like use of whole or part of an image without, like these are just a non-exhaustive list of examples that I have given. Like it can like depending on the context, like it can be further expanded upon, and I think it's something that will like the list will always keep on increasing. Like for instance, like in like with regard to a image, like let's say one of your friends, they have clicked a very beautiful photograph, like when they last went to the Himalayas and took a very wonderful photograph of the Himalaya hills, like from a good background and everything. Yeah, and you take that photo and use it in your like own account, or even though you're not using it as claiming that you have clicked it, but use it for other purposes also. So that amounts to copyright infringement. Why? Because we have not taken express permission from the original owner of the copyright. And in case of an image, the original owner of the copyright is the person who has clicked it. Yeah. The second is use beyond the scope of license. So it's not only infringement when someone blatantly copies someone else's product. Like let's say, like I am an author, and I have like I have assigned the rights of my book to a production house, a movie production house. Yeah, but I have only assigned a limited scope of it. But then if I come to know that the movie house is using it beyond the scope that I have granted them, like for instance I have probably entered into a one movie deal with them. Yeah, but then later find out that they are making a movie also, and in addition to that they are coming out with a series, a TV series also. Yeah, so in that case where the license is only given for a movie, production of a new TV series is basically use of the right beyond the scope of license. Yeah. The second is adapting an image without permission. Yes. So like these comes mostly in scholarly works. Like let's say, like for instance, you are an art critic. Yeah, and you are writing a paper, and you are basically explaining all the things about, like let's say you are doing an analysis of postmodern art. Yeah, and while you're doing it, you are using like paintings made by famous painters like Salvador Dali, or let's say Monet, like like in your article without taking permission from them. And them in this case is that like they have all died. Yeah, but then what happens is, like whenever someone like dies, whenever a copyright holder dies without with like either in cases they assign it to someone, or in instances where they have they have died without giving any express authorization to anyone else, then it is basically their heirs who can sue you, and it's basically their heirs or some kind of a society or an organization which collectively looks after all the copyright vested over all these things. So you need to take an express permission from them, stating that I'm writing an article and I'll be using the images of this famous painting to do my own analysis. Mm. Yeah. Now, the fourth one is basically making, distributing, exhibiting, importing, and infringing copies of work. So this is something that is like a blatant infringement of copyright. Let's say some let's say Manish Malhotra has made a very famous a very new a very good sherwani, which is which has gotten very popular in fashion circles. Yeah, and some random shop in a let's say in Palika Bazaar in Delhi is making exact copies of it and selling it at a fraction of the price. Yeah, so in that case, that is a blatant infringement of copy. There are no two ways about it. Yeah, and then unauthorized exercise of exclusive right available to the copyright owner. So this is a basic. So this one is a corollary to the second one, that the use beyond the scope of the license. So it's basically they're just exceeding the authority given to you to use it. Yes, so there are just a few tidbits of copyright infringement. So it essentially comes down to using someone's creative work without their permission. So if someone publishes a story online and you use a photograph you found on the internet, but you do not get the photographer's permission to use the photo, nor do you pay to use the photo, you have infringed on the photographer's copyright. This is true even if you did not profit from the use of that photo. Profit does not determine infringement. So this is something that needs to be taken care of. Like a lot of people feel that if copying is done and it is not done for a commercial purpose, in the sense that the person who's doing it is not does not stand to gain anything from it commercially speaking, then it is not copyright infringement. But the answer is no. Like when any unauthorized act is done, then itself it becomes an infringement, whether the person stands to gain or lose from it. That is the basic understanding. Mhm. Yes. Now, since I've told you what is infringement, I have to tell you what are the defenses also, because it's not because it cannot be this that a blanket protection is given to everyone. Yes. So the basic the most important difference is the concept of fair dealing. Yes. So fair dealing is basically the term that is used in India. In the in abroad, especially in other Western countries, what the word is used is fair use. Yes. So fair use basically is to define it. Fair use is basically when our narration of certain instances which is contained in section 52 of the Copyright Act, which if a work is used in that particular manner, then it will not amount to copyright infringement. Yeah. So now what are those instances? So the basic thing is this, that fair dealing it includes things such as criticism, personal use, newspaper report, review, etc. Let's say you are you are just whatever is you want to any particular government policy has come out, or any particular private any your company also has a policy or anything like that, and while doing that you are basically you are writing a research paper on it, or you are writing an article on it, and while you are doing it you are using the company logos and things like that, and any other copyright and any other subject matter on which the company has a copyright. Yes, so in those instances, like you are not amount like your act does not amount to instances, like your work does not amount to infringement, because like you are doing it for a critique and to basically write a newspaper report. Yeah, any kind of judicial proceedings, like what happens is like whenever a court gives a judgment, yeah, so uh, that is something that is does not like that is always available in the public domain. Yeah, so you can freely take out texts from that judgment and use it in your own article, in any manner that that you want, without incurring infringement, because it is contained under 52 of the act. Yeah, then some kind of exclusive work of member of the House of Legislature, yeah, non-corporate matter for educational purposes, any kind of question papers, then or things which you have done with consent, yeah, where the audience is a non-paying audience, yeah, and the issue being something that is of like current affairs topic, and it relates to the economic, social, and political well-being of the country. Yeah, and like less than 3 copies has been made of it. Like you have only shared it with 2 people only, and that's one instance. Like you're doing it for any kind of private study or research, or that particular like work is available on the official gazette, which is released by the government from time to time, or it is a report of some committee established by the government or some parliamentary commission. And the last one is that once it has like expired copyright, and it falls under public domain. Yeah, so these are just this is again a non-exhaustive list, and this is just a narration of few practical instances, like with the rise of digital media and everything, and the progresses that we are making in technology every year. Like there can be many other instances, like practical instances, which comes up, which are not defined or not particularly listed down over here. But then if it falls under any of these similar principles, yeah, then also like it will amount to fair dealing. Yes. Now, for instance, now as I've explained what is infringement, now I think I should take some time to explain what are the remedies available to an or to a copyright holder who feels that their copyright has been infringed. Yeah. So the remedies, like any kind of legal remedies, are basically divided into three. First is civil remedies, where you approach a court of law in a civil action and ask for injunction or damages and things like that. The second is a criminal remedy, where you file a complaint with the police, and then the police like and then the police takes further action on it. What are those actions? I'll come to it later. But the first one is civil remedies. So I'll be describing it that. So civil remedy is basically like whenever, like let's say you are like as a author, you have come across an instance where you feel that your copyright has been infringed. Yeah. So what you by a particular person, then what you can do is you can file an injunction at uh, a court nearest to like like to, at a court which at a court which has the relevant jurisdiction. I should that. Yeah, so you can file an injunction suit against that person, stating your case that this person is infringing my copyright, and an injunction should be given by the court, and he should be injuncted from using uh, my work product for any future purposes. So this is one kind of remedy. And now second kind of remedy, which can be added to the first, like it's not mutually exclusive, like it's like one after the other. Yeah, is damages or accounts of profit. Yeah, so when you are asking for an injunction, in addition to it, you can basically ask for damages also. That the fact that that person is using my copyright means that I have incurred certain losses. Yeah, and because of the same, that person should pay me damages worth a particular amount, which should be also reasonably justifiable with the work product at hand. Like let's say, like your like you are an author, you have written a book, and a movie production house unauthorizedly makes a movie out of it, and in that instance you can probably file a suit with and claim damages of 1 crore, because that movie production house itself is a big entity. Yeah, but then if you have written a research paper and your friend has basically copied it and submitted as their own, then in that instance you cannot claim an absurd amount of 1 crore, because the claim of damages should be in context to the losses suffered. And in this case, like an injunction is enough. Like you don't have to get damages out of your friend, because the entire act is not done for any commercial purpose. Yeah. And during and while you are claiming damages, one thing that needs to be remembered is this, that the person who's claiming it needs to basically justify and needs to prove how he has suffered losses, like through an actual like account of profit. Like he should give an actual account of how much of profit the other party has made, which basically amounts to his loss. So it's not only a random amount that you can claim. It should have like it should be proportionate to the context and the facts at hand. Yeah, yeah. So, and in a civil action, what happens, like what like in addition to injunction and everything, what you can do is like you can ask the court for raids and seizure also. So this is particularly helpful in instances where, like, let's say designers, or like a very practical and relatable example is basically like the piracy of CDs. Yeah. So nowadays, like that is like, I think CDs have gone out of use still uh, to quite an extent, and we are mostly reliant on digital media. Yeah, but then there used to be a time when like like when I used to when I started practice like 6 years back. So at that point of time, like yeah, like data leakage and sharing of information, and especially pirated content through CDs, was something that was very prevalent and used very much. Yes, so in those kind of instances, what happens is movie production house, they basically do their own investigation. They go to the particular place wherever those things are being sold. They do it obviously in a clandestine manner. Yeah, and like so that the people, the pirates, don't find about them. Yeah, and once they get hold of it, what they do is they file a suit for a raid at the court of law, stating that like we have this information, and they submit all evidence to the court that that this particular person from this particular shop is basically selling like pirated content, and we want the court to basically authorize us, along with the help of a police officer, like in the nearest geographically located police station, to basically like help in the raid of all those products. Yeah, accounts of profit is something like is instances where basically when the court is satisfied that there has been an infringement that has taken place. Yeah, they basically ask the infringer to basically submit their own account book to know how much of money they have earned for things like from selling it, and etc etc. Yeah, and another kind of remedy is also this, that delivery and destruction of infringing goods. So this is only relevant in context to infringing products which are uh, like tangible in nature. Like let's say, like for instance, in the farm, like in the pharmaceutical world, what happens is cheap and fake medicines is also something that is very prevalent, and it is it is being like it is present in a lot of shops, like a lot of like vendors, what they do is they sell fake medicines. Yeah. So if any particular pharmaceutical company has has come across such situation, then what they do is they basically like sue for an injunction against that particular person, and also asks the court to mandate to the other person to deliver that particular like all the goods that are infringing, so that it can be destroyed, and it does not again land up in the market through some other bad channels. Yes, so this is what civil action is. And while you are taking a civil action, there are certain legal terminologies that I'll just take you through. One is an ex parte order. So an ex parte order is basically like so in many of the blatantly infringing instances, like where, like for instance, people are selling fake products, counterfeit products out of Palika Bazaar and Sarojini Nagar. So in those instances, when you file a suit, what happens is the other party never lands up in court because he knows that he is doing it, and flying of counterfeit like counterfeit is basically his business model. Yeah, so he'll never end up in court. Yeah, but then like if the other party does not come, what happens? Like, will you not get a remedy? No, it is nothing like that. If a person does not appear to like at the court, then what the court can do is they can pass an ex parte order. So what is an ex parte order? It has four basic features. First is when the matter is extremely urgent, you have to show that like urgency, and like if it is not catered to now, then like you will suffer some kind of a loss, or the matter is really serious in nature, and the plying of counterfeit products also relates to other criminal activities, etc., etc. Then at the preliminary hearing of the interim application, without notice to the answering the defendant, like all the notices, like that are sent has not been answered by the defendant, or like at the interim stage. Yeah, so in that case, it is granted before the motion of for interim injunction is fully heard, but for a limited period only. So when the party is not turning up and is refusing to comply, so the ex parte order that you get is not a perpetual order. It is always for a fixed period of time, and like the court will mandate that yes, since the other party is not turning up, what we can do is we can give you a remedy, but it will only last for 6 months or 12 months at the max, depending on the context of things. Yeah. And now, after the grant of ex parte injunction, the court must proceed with the disposal of the interim injunction application after the defendant has entered appearance. Yeah. Now, another is John Doe order. Now, John Doe order is something that is very important, especially in light of uh, the leaps that we have taken in digital media technology and things like that. Yeah, so John Doe order is basically, so John Doe basically refers to orders where you do not you cannot identify the other party. Like for instance, in like especially in the online world, what happens is like a lot of production houses, they go through this problem time and again. Like there are multiple websites that are basically hosting your movie, like pirated websites. Yeah, so in that instance, how many parties will you basically like implead in the application? Like there are so many people that you can't like it is not physically possible for you to check each and everything. And even in the physical world, like let's say like something like let's say Nike shoes, or Adidas shoes, like that is something that is like counterfeit versions of it are sold across every market in this country. Yes, so how many people will you add to the plane? Yes, so the basic thing in John Doe order is basically where the plaintiff approaches the court and mentions that an order, like we need a against everyone, uh, whoever is doing a particular act, and that act of infringement is defined in a limited manner. So whoever is doing it, you gave us a so a John Doe order is whoever is infringing that, the holder has a blanket right to basically enforce their order on anyone who is user who is using it, even at a future point of time. Mm. Yeah, practically how it turns out is this, that if you are the legal officer of Red Chilies Entertainment, and if you see that there are multiple websites that is using the new Shah Rukh Khan movie that has come out, then what you do is you approach the court and you say that it has come to our information that a lot of websites, and you narrate a few of the websites, list them down, that websites, these are the websites which are hosting it. We want a court order to immediately stop those websites from hosting it, as well as any other future websites of similar nature who also use it at a future point of time. Yes, so in that case, what you do is you do not have to go to the court again for another order. That initial one order is enough to for you to bring other parties and to enforce your right against other parties, especially when the cause of action arises at a future point of time. Yes. Now, an pillar order. Yes. So these are so this is something that is mostly relevant to an instance where the counterfeit product is basically something that is physical in nature. Yeah, and it is an order where the court requires the defendant to permit the plaintiff to enter his premises and take inspection of relevant documents and articles and make copies thereof, or remove them for safe custody. Yeah. But to get a prima facie order, what you have to do is you have to fulfill certain preconditions, and those preconditions are, like, you have to have an extremely strong prima facie case. Like all kinds of like the damage from that case will be like even potential damages or the actual damages is very serious. There is a clear evidence that defendants have in their own possession infringing or incriminating documents or materials which they may destroy at a later point of time. So, like an Anton pillar order is very relevant in instances of pharmaceutical infringement or FMCG in infringement, where there is information that a huge amount of goods will basically be released into the market, and it'll fake goods will be released into the market, and this is basically like a one-stop option to stop. Yeah. Now, coming to damages. Yes, so damages one I had mentioned it before. Yes, so damages, you can claim damages, but then the standard of proof to get damages is much higher, and you have to prove through books of account how much loss you have suffered. Yeah, and also one thing that needs to be remembered is that, like in case of damages, like it is not a right that you have; it is something that is discretionary by the court. So only when the court gives, like in their own discretion, thinks that if the person deserves damages, then only you'll get one. It is not a right. It is not a matter of right for you. Yes. So these are certain other civil, like how to get the other pecuniary remedies, how to get damages. Like these are mentioned under section 55 and 58 of the Act. Yeah. So an account of profit which lets the owner seek the sum of money made equal to the profit made through unlawful conduct. So these are just yardsticks through which you measure damages. Yeah, compensatory damages when which lets the copyright owner seek the damages he suffered due to infringement, or conversion damages which are assessed according to the value of the article. Yeah, now according to accounts of profits, yes. So this is basically uh, how the plaintiff requires the defendant to disclose like actual accounts of profit. Yeah, so actual accounts of profit can be proved by the GST returns of the infringer, any kind of import-export record from the official records of the custom authorities, Yeah, number of, like, if it is online in nature, then number of hits on the infringer's website. Yeah, and information from other e-commerce marketplaces. Yeah. Now coming to criminal remedies, like till now, all the remedies that I had described was mostly civil in nature. So now we come into criminal remedies. So the criminal remedies basically like are a few, like it's section 63 of the Copyright Act, which mentions the offense of infringement to be criminal in nature. Then section 65 of the Copyright Act, section 65A of the Copyright Act, which is basically an extension of 65 was basically drafted much before, and at that point of time, we did not have much use of digital media technology per se. Yeah, so 65A is basically talks about technological protection measures that like how to basically stop infringement, like what constitutes infringement in an online manner. Yeah, and 65B of the copyright deals with information rights management. It's basically a very complicated, like it's not a complicated, but it's like it's a system of like rights management that is there. Yeah, and then criminal penalties that are there, like section 63A of the Copyright Act, like provides criminal penalty to the holder of the copyright. And in that instance, like when you are going for a criminal remedy, then what you have to do is you have to produce your registration certificate. Without that, like generally what I have seen is that practically police officers refuse to file an FIR without it. Yeah, yeah, and like section 63A, something which provides for enhanced and compoundable penalty for second and subsequent convictions. So this is very important for all these counterfeit sellers who are available on Palika and Sarojini. That if they're caught a second or a third time doing the same thing, then the gravity of that offense increases, and the term of imprisonment also increases quite substantially. Yeah, and then section 64 basically mentions the power of the police to seize infringing copies once it's proved to the police's uh, own satisfaction that an infringement has taken place, and the owner's right has been violated, and how to further get other criminal penalties, which is mentioned under section 67 to 70 of the Copyright Act. Yeah, and now just to mention the quantum punishment through imprisonment under section 63 may not should be from like it is from a period of 6 months and extended to a period of 3 years. Yeah, and section 63A provides for like enhanced penalty. Yeah, and under section 63, what you can do is like you can get uh, an enhanced penalty and a fine can be imposed, which can like go till 2 lakh rupees. Like that is the maximum amount over there. Mhm. Yeah, and Section 65A penalizes circumvention of effective technological measures that may be applied to copies of a work with the purpose of protecting any of the rights conferred under the Act. The punishment under this provision is imprisonment that may extend to 2 years and a payment of a fine. Section 65B makes unauthorized removal of or alteration of digital rights management information punishable with imprisonment of up to 2 or 3 years and a payment of fine. So this digital rights management information is basically a system of like it's basically an instance, like a very instance will be where when like you are basically going to someone's website on which they own copyright over it. Yeah, and like through uh, through your own means, what you do is like you alter that website, or you change things, the source code of that website in such a manner that website does not function or functions defectively. So that is basically a violation of a rights management information contained under section 65B. Yeah. So So now I'll just come to a few important case laws. Yeah. So the first is the case of Phillips versus Amaze Store, where so Phillips had their own copyright, like uh, their own product of trimmers, over which they had patent, copyright, trademark, all kinds of IP on. Yeah, and what Nova did was they basically copied the same in some manner, like which looks quite similar to that. Yeah, and the packaging and everything was also quite similar. Yeah. So you can just see like the degree of similarity that was there. Like there was a rectangular shaped box, like the blue colored background theme of the box was there, thin white strip near the top of the box with trademark written in blue front. Same with Philips and Nova, uh, and everything. So the degree of substantiality is very palpable in the first instance itself. Yeah, yeah. So in this case, what happens was like like it was, so the main contention of this case was design infringement. Yeah, which I think like there's a session on design either tomorrow or day after tomorrow also, and the other speaker will take you in detail through what is design infringement. Yeah, but in addition to design infringement, what was also held over here was that, like, the fact that the defendants, they were using in an unauthorized manner the literary and artistic work that the plaintiffs contain in the original product. So it means that it is an infringement of copyright also. Yeah, and because of this, and because of the fact that it was all done uh, for profit making purposes, the court granted compensatory damages worth this much. Like, what is the amount? It's 2 crores. Yeah, it's 2 crores, 15 lakhs 71,000 something. Yeah, this was the compensatory damages given to the plaintiff, and in addition to that, they gave exemplary damages of 1 crore rupees for their blatant infringement. Yeah, in addition to the cost of litigating the suit and the lawyers' fees and things like this. Hmm. And like this is also like a degree, like a principle related to damages, which was laid down by the court, that like if the degree of malified conduct in the proportionate amount of award also keeps on increases the basic this thing. Yeah, and another very important example, which is very relevant in these days, especially when we are all working from home, and the use of digital media and digital technology has skyrocketed more than ever before. So this was basically a case called UTV versus 1317x.to. This is basically the name of the infringing website. Yeah, and this is for the first time. What happened in this instance was that a dynamic injunction was granted. Yeah. So what is a dynamic injunction? So it was that the defendant's website, which was 1337x.to, they were like blatantly pirate, like uploading pirated content of different movies and series, and proven that they were uh, 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 have been infringing. But then what UTV over here they asked the court was basically a dynamic injunction, in the sense that today they know that this particular website is doing it, but from their past experiences they have gotten to know that, when you stop one such five other such websites. Yeah, so the court want the like UTV basically wanted a proper and remedy that was granted by the Delhi High Court was this, that it said that, like, you have a right to injunct any other similar websites which is also hosting pirated content. And in addition to that, the court also directed the Ministry of Electronics and Information Technology and the Department of Telecommunications to come up with a technologically feasible method to warn content in infringing viewers. Like it's basically like the court mandated the government to come up with a guideline where, like, if anyone is even unknowingly using or streaming pirated content, then some kind of a alert should be given to him informing that they are accessing something in an unauthorized manner. And the last one is administrative remedies. Yes, so administrative remedies is basically the third one. Like the first was civil remedies, second was criminal remedies, and the third is administrative remedies. So administrative remedies is basically when you are you approach any administrative authority of the government, and this is laid down under Section 53 of the Copyright Act. It basically like gives you the opportunity to go to the registrar of copyrights who issues all kinds of copyright registration certificates, to basically like to make a request precluding the importation of India of any of such duplicates for the utilization of the proprietor the copyright in any work, partly his obligation agent wake of making such a request as he esteems. So it's basically an instance. So this is only relevant when the prime channel of infringement is happening through in an import export environment. Yeah. So what happens is you have to make an application to the registrar that mm, along with evidences that I have information that my copyright is being violated through these channels and through these custom routes. It is being imported into the country or exported out of the country. So we want an order from the registrar of copyrights to basically like stop this, and to direct the custom official to take action whenever such products is coming for import or export, even in a future. Yeah. So and in addition to that, there are other laws also in force. Like for instance, there's a intellectual property rights imported goods enforcement rules, which mention instances where things are imported, where it is imported, how to get a remedy on that, and then there's a IPR customs recordal portal also with the customs authority, where if your IP is registered and it is recorded with the customs authority, then you can directly approach the customs authority for a remedy and stop any particular implying of goods. Yes. So border protection measure is basically the extension of administrative remedies only, where instead of like approaching like you directly approach the border authorities to stop to stop infringement. But in that case, you have to have other evidences to prove, and you have to have other orders either from the custom officer or from the court. Yeah. Now coming to the last part of this presentation, which was the filing process related to India, like in India. Yes. So for that, I've made a basic flowchart of how the entire registration process works. Yeah, so this is the basic flowchart, and I'll just explain the whole process. Yeah. So how it works is that, see, copyright, like I have told you the various work, like the various subject matters of copyright: literary work, dramatic work, musical creation, cinematographic films, etc., etc. Yeah, but in terms of classification, copyright is basically divided into two kinds of work. One is art, artistic work, which is being used as in respect of goods and services, and any other kind of work which is literary, dramatic, music, cinematographic, sound recording, etc., etc., which is not used in respect of goods and services. So the basic difference between this and this is this, that like let's say for instance you have made a painting, and you have made a painting, then it will be under this category because it will be a literary and dramatic work. But then what you do is the painting becomes so popular that you basically print it in a t-shirt and also sell it as a merchandise. So in that case, what you are doing is the literary work that you have, you are basically using it as a good and service. So the modes of registration for both of this is a little different. So the first and the most simple one is basically that if you think you possess any product which comes under literary, dramatic, musical, cinematographic work, film, sound recording, or artistic work, like not being used with respect to goods and services. What you do is the first step is to basically file a copyright application with the copyright office. So and like that you can do by going to the website, which is copyright.gov.in. So that is the registrar of copyright's website, and filing is both online and offline. But offline, like the physical filings these days are closed because of COVID and everything. So mostly online filings are taking place. Yeah, but like I'll tell you by experience, like 5 to 6 years before, like mostly all filings used to take place in a physical manner only. Yeah, but then since then the office has invested a lot in technology, and now the entire filing process is online, and you can just like file an application, even you yourself, you as the owner of it. Yeah, so and why, and when you are filing an application, what happens is the office issues a diary number on that particular date itself. So you get a particular number through which you can track your application. Yeah, and once that number is you have gotten that number and the filing has been done, what happens is it then moves to the examination stage. Yeah, and that examination is largely done within a range of 1 month in normal circumstances. Though after after the COVID, like most of these cases are not happening in 1 month because of various reasons, like logistical and a lot of other things. Yeah, so but then like it generally, like before this, I like according to my experience, like all throughout 2017, 2018, 2000, like till the end of 2019, it used to happen within 1 month. Yeah, so so once the registrar examines the application, basically depending on other records on the register, what it issues an objection letter if something is something objectionable is found, or your copyright is basically similar to any past copyright that is already existing in the records of the registrar. Yeah, so if that is the case, then they will issue an objection letter to you. And if it is not the case, if the registrar finds that the product is uh, uh, has sufficient originality in it, then after examination, it will straight away proceed to registration. Yeah, but these are like only the best instances, and not all instances happen in this way. Yeah, so if an objection in cases where objection is found, and then like they issue an objection letter to which you have to reply within a period of 45 days. And if you refused or abandoned, as in your application is rejected, and you have to basically, like, on grounds of non prosecution, if you do not file it within 45 days. Yeah, and after you file it, then what happens is the registrar gives you a hearing where you basically go to the office of the registrar and justify why and how your work is like your work is original in nature, and why it deserves copyright. Yeah, in the hearing, if the registrar finds everything is okay, then it proceeds to registration. Otherwise, it is refused or abandoned. This is for all kinds of work which is not used in respect of goods and services. Now, for instance, coming to works that you want to use in respect of goods and services. Yes, so what over here, what happens is that so any artistic work which is used in goods and services comes in conflict with a trademark that that is either registered or which is registered. Yeah, because a trademark is something that is used in respect of goods and services. So the registrar wants to make sure that the thing that you are applying a copyright over does not contain, does not be in conflict with a trademark also. Yes. So because of this, what you have to do is like uh, while filing, you also have to request. Uh, you have to make an application under Form TMC to the Trademarks Registry for an issuance of NOC from their end. So that NOC will particularly be from the Registrar of Trademarks, and he'll basically mention that to the Registrar of Copyright that the particular artistic work that is being applied before the Copyright Office for registration does not conflict with any marks that is registered on the official register of the registry. Yeah, so that is just a kind of NOC. Yeah, so in instances where you do not get an NOC, you cannot file the application. Yeah, and if you do it, then it will be refused straight away. Yeah, and if you have an NOC, then you again go to the normal route that you have to file the NOC along with the application. It will go to then once the registrar, the copyright registrar peruses it, they'll issue an examination report, which needs to be replied within 15 days in this case. Yeah, yeah, and then like if it is not done, then like if it is not done, then it will be straight away refused. If it is done, then and if it is found in order, then they can proceed to registration. If it is not found in order, then they'll basically go for a hearing. And once that is done and you prove everything, then only it goes into the normal route again. Yeah. So this is the entire like copyright process flowchart that you do in the country. Yeah. Now moving on to the second part of the topic, which was WCT. So WCT is basically the World Intellectual Property Organization Copyright Treaty. It's called WIPO Copyright Treaty or WCT. Yes. So what happens is like in addition to national laws, there are also a lot of international laws which has come in force uh, because of like agreements and treaties between governments. Yes, so WIPO Copyright Treaty is one such treaty, and India is a signatory to it. It in fact it recently ratified, like as late as 2018, I guess, if I'm not correct, if I'm not wrong, that India acceded to it. Yes, so WCT is basically like it is also popularly called the Internet Treaties. Why I'll tell you. Yes, so it is basically an international treaty on copyright law adopted by the member states of the World Intellectual Property Organization. Yeah, it provides additional, like that treaty basically provides additional protection to copyright to respond to advantages in information technology uh, infringement and things like that. Like the reason for this treaty is this, that like considering the advantages and the leaps that we are taking in digital technologies, like if in instances where the domestic legislation does not give remedy to all kinds of infringement in the digital media. So in that case, what happens is like the World Copyright Treaty gives you an additional layer of protection. Yes. So what are the protections granted by the treaty? The WCT emphasizes the incentive nature of copyright protection, claiming its importance to creative endeavors. It ensures that computer programs are protected as the literary works, and that the arrangement of selection of material in databases is protected under Article 5. Yeah, it provides authors of works with control over their rental and distribution in Article 6 to 8, which they may not have under the Berne Convention alone. And it also provides circumvention of technological measures for the protection of works and unauthorized modification of rights management information contained in the work. So this thing, like compared to the Indian law in force, this is just something that gives an additional net of protection that in case the context and the facts are such that under Indian law per se you are not getting a remedy, so then you can also include instances and remedies from this particular treaty. Yes, I think yes. So that will be all from my end. And like, if there is any questions, then I'll be happy to take them.
Thank you, sir. User can write their questions in the chat box.
Okay, I'll just see.